Oh yeah. What I've forgotten is... Otherwise, we've got problems with the voice. Because there, I think. That.
They need to read your lips then.
Yeah. But sometimes my lips are working faster than the sound. So with this, inshallah, hopefully they get both together. بسم الله الرحمن الرحيم الحمد لله رب العالمين والعاقبة للمتقين والصلاة والسلام على أشرف الأنبياء والمرسلين محمد وعلى آله وصحبه أجمعين. Last week we did about ijma. I'll give you the sheets afterwards, the lecture notes.
Easy with work and stuff.
That's no problem, inshallah. But if you get time, I've put a link to the YouTube. If you watch that, that will be really helpful, inshallah. And feel free to be a bit more interactive. And Faizi, he will be with us for a while, then he'll appear because he's got something. Bismillah ar-Rahman ar-Rahim. We are talking about Qiyās today. Qiyās, literally it means to measure something using something. Or something with something. Yes? Like for example in Arabic, I can say قست الأرض بالمتر أو بشريط القياس. That is, I measure the land using a measuring tape. Yes? A measuring tape or with a measuring tape. It is sometimes used to compare something with something else for learning the relationship between the two. Yes? Like for example, I'll give you whether that thing is tangible or intangible. Compare. Like for example, I can say, if it is something tangible, I can say this table is bigger than that table. That's tangible. Yes? Or this door is smaller than the other door. So what I'm doing? A comparison. So Qiyās has got the meaning of measurement and also has got the meaning of comparison, to compare between two things. Obviously, you will be comparing sometimes with something which is a standard. Yes? You can say whether that is falling short of that standard or not. Yes? So you could do a comparison by saying, well, this is better than this, or this is worse than this. Yes? So, like intangible things as well, you can compare. I'll give you an example of that. I can say today is hotter than yesterday. That's intangible. Yeah? You cannot touch. You may feel, but you can't touch. It's intangible. So the word Qiyās can also be used for that. Yes? To compare between two things, whether they're tangible or intangible, that's irrelevant. Yes? Irrespective of whether they are tangible or intangible. The example of something which is tangible, I can say, قست الورقة هذه الورقة بهذه الورقة أو بتلك الورقة. I compare this paper with that paper. Yes? I've compared. Yes? Example of something which is intangible, I can say علم فلان لا يقاس بعلم فلان. The knowledge of so-and-so cannot be equated with the knowledge of the other so-and-so. Right? I can say that, this person, his knowledge is more than the knowledge of that person. You cannot equate it. Yes? So what I'm doing, I'm comparing his knowledge with... So, yeah. So the word Qiyās has got both meanings of measurement as well as comparing. According to the terminology of the Usuli experts, or Usul experts, jurisconsults, Qiyās, which is analogical inference, is defined as basing an issue concerning which no textual evidence is cited on the injunction of that other issue whose textual evidence exists because they both share the same illa, analogical reason or ratio legis, which allows the extension of the injunction to its counterpart. Did you understand? Yes? So what happened is that we've got issue number one. There is a textual evidence for that. There's another issue number two. There's no textual evidence regarding that. However, both these issues, they have an analogical inference. Yes, they have a description which is the same. So what you are doing in reality, you're extending now the hukum of this issue whose textual evidence exists to that issue whose textual evidence doesn't exist. I'll give you a very simple example. Yes? Say for example, somebody comes to a mufti and says that, there are these mushrooms, when you take them, you become like drunk. Is it halal for me to eat or not? There are these mushrooms or there are these tablets, if you take them, you become like drunk. Am I allowed to take them or not? Yes? Now, is there anything about mushrooms in the Quran? Is there anything about these tablets that cause intoxication? No. So, what a mufti will do, he will say that what is the illah? What is the reason, the main reason, the analogical reason, the analogical inference, yes? Or the legal reason. What is the legal reason or the legal analogy or the legal the legal reason why this thing has been made haram, meaning the wine which is in the Quran? It is because of it creates that intoxication. It bends the mind, it makes a person becomes completely drunk. This is the reason, because of a person becoming drunk. Yes? Now, these tablets, they're causing the same effect. Yes? So, that legal reason is found there as well. But there is no hook, there's no any textual evidence regarding those mushrooms. So, what you're doing now, you are extending the hukum of prohibition of wine to this issue, which is eating mushrooms or taking tablets, because of the fact that both of them are sharing the same legal reason, illah. Is that clear? Yeah. Moving forward, or it can be defined. The other way to define the qiyās, now this process of doing this, yes, of comparing and then extending the injunction of prohibition to the other issue. Because look, about mushroom, is there anything in the Quran mentioned? No. So you will ask the mufti, why are you saying it's not allowed? He will say, the reason being is that it causes you intoxication. So he will say that, oh, intoxication, how did you deduce that? How did you conclude that? He will say that, look, Allah has made the wine haram because of the reason, legal reason is intoxication, and this also contains intoxication. Hence, both of them are sharing the same legal reason. Just as wine is haram, therefore, yes, because of intoxication, the other one is haram. So what you are doing, that process of analogy is known as qiyās. Okay? The other definition is equalization of an incident concerning which no textual evidence has been reported with an incident concerning which a textual evidence has been mentioned due to the equality of both incidents in the analogical reason of the injunction. Again, it is just saying in different words. Yes? You are what? Equalizing or comparing. Yes? You're comparing both issues and you're saying, well, that issue looks like this, though there is no any Quranic injunction about it, but because it looks like this, therefore that is also prohibited.
Who is the person making qiyās right now?
A qiyās would be either a mufti or a mujtahid who will do it.
Okay. So if I'm just getting right, when we are saying ijma, we are backing up with taking backward with Sunnah and Quran.
Yeah.
But when we are making qiyās, we are making analogy and then we are comparing. But on ijma, many people doing same thing, then they come on one conclusion, then we are saying this is ijma.
Yeah.
But in qiyās, if only mufti said, okay, this is qiyās for me, we're going to accept that. Is it right?
What it is, ijma is a bit more stronger than qiyās.
Qiyās. Okay.
Did you get it? Ijma is a bit more stronger than Qiyās. What we will be looking...
Is there any other difference?
what is it, sorry?
Is there any other difference between ijma and qiyas?
Well, in ijma what it is, because there is in Qiyās you're also using Quran and Sunnah as what? As a backdrop, or as a background, or a base, or a foundation from which you are extending that injunction to other things that look like the same. Yes? In ijma what's happening is that you're bringing all people to deliberate and discuss, and all of them come to the same conclusion. They say, well, we conclude that this thing is halal, or this thing is haram. Yes? So that, that agreement, mutual agreement of everyone, obviously they're agreeing based on their understanding of Sunnah, their understanding of Quran. So that's ijma. But in Qiyās what it is an individual decision making process where a mujtahid does ijtihad, and in that ijtihad he uses qiyas to come to conclusion, or a mufti does again ijtihad and he comes to that conclusion as well. Is that clear?
Can you find illah in hadith rather than Quran?
Yes.
Okay.
Illa can be found in hadith as well,
Quran.
and also in Quran as well. Yeah.
Sure.
Yeah. Illa can be found in all, hadith contains also injunctions. You can find a illa, you can also extend the hukam from there as well. Right, in summary, since both share the same illa, that is the analogical reason, hence the injunction backed by the textual evidence is extended to the issue which has no textual evidence. True? Yes. Now, the explanation for this is that the lawmaker has explicitly mentioned a textual evidence concerning a particular injunction related to a particular incident. The mujtahid has recognized the illa, analogical reason behind that injunction. So what a mujtahid does really is that he says, Allah has made the wine drinking haram. What are the reasons? There might be wise purposes, yes? Drunkenness can cause accidents, yes? Car accidents. Drunkenness can cause brawls, yes? Pub brawls, yes? Drunkenness can cause enmity. These are things even Allah mentions, yes? It is, Allah says it's handiwork of shaitan. It is a thing that does not make you successful, rather it makes you unsuccessful, right? All these things are wise purposes. But what is the main reason behind it? Yeah? So that is illa, yes? Yes? The others are wise purposes, right? And that legal reason can now allow that hukam to transmit, or that hukam to extend to other issues that have the same illa. Yes? The mujtahid has recognized the illa behind the injunction. Then there appears a new incident whose injunction has not been mentioned. However, both these incidents equally share the same analogical reason. Hence, the mujtahid is able to insert and extend injunction hukam to the incident containing no textual evidence. The whole process of deduction and attachment of injunction to the other incident having no textual evidence is known as qiyās. So what he is doing is, it's not a new injunction he's creating, he's just extending that injunction of prohibition to other elements. Yes? Like for example, I'll give you another example. The Hanafis, they say that the word in the Quran regarding the prohibition of wine, it is wine in itself, khamr, wine made of grapes. Yes? Now other alcoholic drinks, yes, that are causing the same intoxication as a wine, they've been brought in, according to the Hanafis, through qiyās. Are we understanding? The word that Allah has mentioned in the Quran is the word wine. Yes, Allah did not say Carlsberg. Allah did not say lager. Yeah, Allah didn't say whiskey. Yes, Allah subhanahu wa ta'ala didn't say cider. yes, all these other different drinks are being brought into that prohibition through Qiyās, yes, because why? In wine, the reason of its prohibition is intoxication, hence in all other products, yes, there is intoxication, therefore they're all prohibited. That's according to the Hanafis, yes, yes, but others they say no, okay, but the Prophet ﷺ has said kullu muskirin haram. What did the Prophet ﷺ say? All things that cause that intoxication, yes, of the mind are all haram, yes. So that's okay. The Usuli experts may use different words to explain the process of Qiyās, such as saying, now when the Usuli experts they do Qiyās, sometimes they don't say, oh, we have done Qiyās, yeah. What they might say, here we have an equality in these two incidents concerning the injunction. They might say, oh, these two injunctions look the same. What will they say? These two injunctions, these two issues look the same. Therefore, we can extend the injunction from here to there. Yes? Issue A and issue B, both of them, they look the same because both of them share the same legal reason. Hence, we will extend the injunction of either being halal or haram or whatever injunction is on it. We will extend it to issue B. Yeah? And issue A has already got a textual evidence, whether it's Quran or Sunnah phase. Yes? And then that extension is done. Also, they might say, here there is an extension of an injunction from one incident to the other, and so on. Whatever words they use, in reality, they're pointing towards the fact that they're doing Qiyās. Yes? Turning further, thus Qiyās does not establish a new hukam. Now remember one thing that I've said, that you are extending the hukam. You're not bringing a new hukam. And Mujtahid is not bringing a new hukam. And he's not in the power of bringing a hukam. Do you understand? Because of the fact that hukam comes from Allah. Yes? Allah is the lawgiver. The Mujtahid is not a lawgiver. He is there to explain the law. He's there to extend the law, saying that the law is not confined to just wine drinking, but it is extended to all other alcoholic drinks. Is that clear? It only reveals the injunction that was already established textually for an issue from which the Qiyās was performed. Look, Allah subhanahu wa ta'ala, if he ended up mentioning, imagine if Allah said, cider is haram, this is haram, and Allah enlisted, then the Quran would be in what? 5-6 volumes. Yes? Yeah? It would be a legal document that then the Hufaz have to memorize all of it. It will be too much. Yes? So Allah subhanahu wa ta'ala is a lawgiver, right? And Allah says, He says this is the command for this, and then He has given us the ability to say, well, what is the reason why this is, what is the legal reason behind its prohibition? Hence, yes, that legal reason allows that command to be extended to all these different types. Yes? And how many different types? Imagine if Allah mentioned some types of drinks in the Quran, right? Later on, because every year new drinks keep on coming into, yes, and new names are labeled. People would say, well, these names are not in the Quran, only these names are in the Quran. So we will, yes? So, are we understanding? Yes? Yes, so this is, in fact, the Arabs in their time, they had how many different types? About 500 different types of alcoholic drinks. Different names they had. So they were also real drinkers, yes? Real alcohol drinkers. Yes, so at the time of process of extending, okay, the outcome was the previous injunction was only discovered in the new issue concerning which no textual evidence is found. after the ijtihad of the mujtahid who stumbled upon a shared illah between the two. Therefore, Qiyās is a demonstrator, right, of hukam and not its establisher. The task of the mujtahid in this regard is to discover the illah of an injunction, compare between two issues, and explain the relationship between them, and conclude that the injunction for both of them is one. Yes. So, mujtahid is not in reality bringing a new injunction, and he is not in the authority of doing that. He is not a lawgiver. He is demonstrating, he is revealing, he is saying that look, that these two things look the same, therefore just as this is haram, this is also haram. He's using qiyas and he's demonstrating that to us, right? Now, the qiyas cannot be done until and unless these pillars are there. In a building, if one pillar is missing, the building cannot stand. The building to stand, it needs all the pillars. So, how many pillars are there in qiyas? There are altogether 4 pillars in the qiyas. Yes, there are 4 pillars. If for the qiyas to effectuate, yes, to realize, these four pillars must exist. If one of them is missing, qiyas will not happen. Is that clear? Yes. The first one is the existence of the principle. Yes. For example, here the prohibition of the wine, which has been textually evidenced, that is the principle. Yes. Which is known as maqis alay, the issue from which the qiyas is performed. Yes. That is the khamr or wine, which Allah has mentioned in the Quran. It is the issue concerning which the injunction is mentioned. Now, the second pillar is the hukm of asl. The hukm meaning the injunction of the principle. Now, the wine, what is the hukm of wine? Halal, haram, desirable. What is the hukm of the wine in the Quran? Haram. Yes? So, you need to know the hukm as well. You need to know the principle, which is wine. The hukm of the, number 2, the second pillar is the hukm of that principle. Yes, it is the legal injunction of the principle which can be used to extend to another issue. Number 3, it's fara. Fara means what? The secondary issue. Yes, issue B. Yes, the asl or principle is issue A, the main issue, and this is the secondary issue, also known as maqis, the one about which the analogy was drawn. It is the issue which does not contain a direct textual evidence. Now, this secondary issue does not have a direct textual evidence. The Quran is silent about it. About those mushrooms or about those other beverages, alcoholic beverages, the Quran is silent about it. It just mentions about wine. And it's in need of qiyas to be performed for the hukm to be extended. So, secondary issue is also available. Yes? And the last thing is the illa, that is the analogical reason. It has to also exist in the both items, issue A and issue B. And that is a quality that is found both in asl and also fara, for which the hukm was revealed, and due to the presence in fara as well, the hukm is extended to it. So, these are 4 pillars, then the qiyas can happen, otherwise qiyas does not happen. As for the hukm which is established for the fara through qiyas, that is actually as a result of the employment of qiyas and its outcome. It is the extension of the previous hukm for the asl. Hence, that extended hukm is part of the pillars of qiyas. Yes, now somebody could say, oh, I have understood, number 1, that we should have issue 1, which is principle. Yes? Number 2 is what? We should have the hukm, injunction of the principle. Number 3, we should have a secondary issue. Number 4, we should have illa. Why don't we have a 5th pillar? That is the hukm of fara. What is the hukm of the secondary issue? We will say, no, there is no 5th pillar, the hukm of fara. In reality, the hukm of fara is the hukm of asl. You have just extended it, yes? You have just linked it to this one, yes? There is no any independent hukam for this. Yes? Yes?
Because you can't make new hukam.
You cannot make hukam, that's the reason. Now, let's give you an example of qiyas. By example, we understand better. Is that true? Yes? Let's give an example. We have got a textual evidence mentioned for the prohibition of wine. Allah subhanahu wa ta'ala says in the Quran, يا أيها الذين آمنوا إنما الخمر والميسر والأنساب والأزلام رجز من عمل الشيطان فاجتنبوه لعلكم تفلحون. O you who believe, wine, gambling, outruns, and divining arrows are filth made up from shaitan. Therefore, refrain from it, meaning refrain from all these things, so that you may be successful. According to a group of jurists, who? The Hanafis. They are the ones saying that, right? According to a group of jurists, the word khamr implies to the intoxicant drink derived only from grapes, which is wine, and no other fruits or sources. Yes? As for other alcoholic drinks and intoxicant drinks, they have not been included in this textual evidence. Yes. According to this group of jurists, due to khamr implying the intoxicant drink derived only from grapes. However, these alcoholic drinks share the same illa as found in khamr. Hence, through qiyās, the injunction of hukam of the prohibition of khamr will be extended to these alcoholic drinks because of all of them sharing the same illa. Did you understand? The second example is, I'll just explain in my words, then I will read. Is that okay?
Yeah.
Okay. What it is, the hadith says, Al-qatilu la yarith. Al-qatilu la yarith. One who kills an inheritable person, he will not inherit. Yes? The killer of an heritable, yes, person. The killer of a heritable person will not inherit. I'll explain to you what it means. Say, for example, if a person kills a person who he was inheriting from, he will not, the hadith says what? He will not inherit. What is the reason behind it?
People will kill all the rich.
No. What is the legal reason why the legal lawmaker, meaning the Prophet ﷺ,
They have relationship father or something like.
yeah, what is the legal reason behind it? What is this?
The greed
The greed.
to kill and usurp.
You get the inheritance then.
Yeah. So what he's really doing is trying to hastening. Yeah. He wants before its natural time. He wants to get the money now.
Yeah.
Are you understanding? So, for example, these things do happen, right? The world is full of how many billions of people, right? So there are people who are very filthy rich, billionaires, right? Grandfather, right? And there is their, grandchild who's grown up in his 20s, yeah? And says, when will the old man die so I can inherit? Yes? Yes? And, Nauzubillah, he ends up doing something. Yeah? To inherit his wealth. It happens quite a lot. Even between husbands and wife and many other things. May Allah protect. Yes? But obviously it's it's a religious life that people sometimes have. They don't have piety and they think this is this is normal for them. But obviously we have the rule of law that then catches up, right? So say for example such a person has been caught that is killed, right? He will not inherit. That's what the Prophet ﷺ says. Obviously he will be punished for that and he will not inherit. Yes, that wealth. Now the question is, this is regarding inheritance. There is something else, bequeathing. You know bequeathing, yeah? Bequeathing is wasiyah. Say for example, Ahmad, yes? Ahmad bequeaths or writes a will that I will leave Muhammad 200,000 pounds from my wealth. He is very wealthy. Yes? Yes? Ahmed is what? Very wealthy. He says, I'll give him how much? 200,000 pounds to Muhammad when I die. Muhammad has come to know about it and he's happy. He says, well, I'll be getting, through what? A will, not inheritance. So he says, well, will this Ahmed guy die? The earlier he died, the better, because I can get the money and I can enjoy myself, right? Yes? So what happens is that he tries to get an opportunity and he kills him. The hadith doesn't mention about wills. It mentions about inheritance. It mentions the one inheriting, not the one regarding whom the will has been written. Yes? So what are the both of them are what they are doing? They are both sharing the same legal reason. And what is that? Hastening, yes, a person's death, yes, before its time, yes, to acquire that wealth. Therefore, he should be punished. And the punishment is he should be stopped from getting that wealth. Yes? So I will read to you and you will understand, inshallah. Killing of a heritable person by a hair is an asl. Yes? Killing is an asl, concerning which a textual evidence with the hukum of prohibiting the murdering hair from inheriting has been mentioned. That textual evidence is the following: Al-Qatilu la yarith. A killer will not inherit. It is a hadith that Imam Tirmidhi and Ibn Majah have mentioned. The illa, analogical reason of the hukam is using unlawful killing. Yes, what is the reason behind, legal reason? Using unlawful killing is a means of hastening the obtainment of a thing, which is inheritance, before its natural time. Yes? He doesn't want to wait for another 2-3 years until the old man dies. So he wants it now and now. Yes? Hence, this bad intention will be repelled, as he will be punished by being denied of acquiring it. Yes, they say there is a maxim in the qawaid fiqhiyya, in the fiqh, amongst the fiqh maxims, من أجل الأمر قبل أوانه أوقب بحرمانه. One who hastens a matter, obviously unlawfully, before its time, he will be punished by being denied of acquiring that matter. So that's what's happening here. He's hastened, yes, unlawfully he is hastened to acquire that matter, yes. Hence, he will be denied of receiving that matter, yes, that inheritance. Hence, this bad intention will be repelled and he will be punished by being denied of acquiring it. Now, the inquiry is concerning the fact that no textual evidence is mentioned in relation to the bequeathed person who murders the bequeather. Yes? Bequeathed person ends up killing the bequeather. There is nothing mentioned. One who writes a will. He writes a will. An old man is writing a will. My grandson, right, will receive 200,000 pounds, right? Yes, the grandson is really happy that he will get it as a will, right? So there's nothing mentioned in the hadith about it. It mentions about the person who is inheriting, not one who is, who is receiving the wealth through will. However, in this incident, there contains an illah, that is to hasten oneself to acquire a thing before its time using the murderous crime, which is exactly the same illah as the illah for the former case, in which a textual evidence has been mentioned. Hence, this latter incident will be attached to the former incident concerning which a textual evidence exists, because both these incidents share the same illah, that is hastening of acquiring a thing before its time. Did you get it? Yeah?
Yep.
The third example is placing a bead over the bead of one's Muslim brother, or marriage proposal over the marriage proposal of one Muslim brother. That is not allowed because of the following prophetic narration. I'll give you an example. Say, for example, Zayd, Ahmed, and Bakr. Zayd, Amr, and Bakr. These are three boys, right? Yes? These three boys, what happens is that Zayd puts a proposal to marry Aisha, right? And the family says, oh yes, we are happy, yes? And we're giving a green light. Yes? Yes? Now Amr comes to know that, oh, Zayd has been given a green light. Now, they're going for, soon they will have a, engagement party. You understand me? If the offer is open, that's no problem. But here is the offer being sealed now. Yes? The offer is what? Sealed. So Amr comes and he says, why are you getting him, Zayd, marrying to, wow, why I should get married to her. Obviously his father will go and say, isn't it, Amr's father, my son should get married to your daughter because my son is wow. Yes? And he's wow, right? And he is really good and this and that. So what he's doing, he's putting a proposal over the proposal of Zayd. Yes? And then Bakr comes along as well, does the same thing. That is not allowed. When it comes to the sealing stage, where the things are sealed, the offer is sealed, the proposal is sealed. Yes, before that, if it's open, when they say that, we are open to offers, that's fine. Yes? But once the closing date has come, meaning that the confirmation has been done, who the person should be, you cannot then put an offer after that. Even when you're buying a house, isn't it? There's a closing date. After that, you try to put an offer. It's not a good thing. Yes? It's not a good thing. So the hadith refuses about it. It says you shouldn't do that. A believer is a brother of a believer. Why? Because what will it cause? It will cause problems, isn't it? When, say for example, Zayd's father comes to know, he will say that, what's happening here, right? We're just thinking of phoning them to arrange for engagement and you just came and messed everything up. Huh? True. Yes? You'll cause problems, A believer is a brother of a believer. It is not allowed for the believer to place a bid over his brother's bid, neither to propose over the proposal of his brother until he quits. Yes, if one pulls out, say for example, if he says, well, now I'm pulling out. If one of them quits, then obviously there's no problem in putting a proposal. That is, when it has reached the sealing stage, yeah? When it is sealed. The illa in this injunction is the transgression against his brother's right and inflicting harm against him, and the evils of hatred and disputation that follow. Obviously, this will cause problems and hatred and disputation and problems after that. Now, the hadith is about buying and selling, and it is about marriage proposal, but it doesn't mention about hiring. Did you get it? Yes? You hired a car, yes, from Arnold Clark, yes? There was only one car left, and it is for Saturday, tomorrow, yes? And they said, that's fine, no problem. You say, okay, it's a provisional booking. They say, yeah, and will not give it to anyone, yes? And you were going to take that car because it's a 7-seater, yes? And your family is extended and you want to take it to Bradford because there's a marriage there, yes? Yes? And now Arnold Clark, they've said it's for you, will not give it to anyone. And who's talking in Arnold Clark? Your best friend, who is a Muslim as well, and who yes? He's a salesman there, right? On the other side, you phone and you hire the car, 7-seater. Now, it's just payment left, yes? Some other brother who wants to also go Bradford, yes? For the marriage, right? You said, no, give it to me, yeah? Give it to me. So when you went to go and pay and, get all the paperwork done, he says, well, Bakr came here and he got the car. It will cause disputation. Now you will phone Bakr, you will say, what you have done? You will also dispute with the person as well there. Yes. But if I pulled out, right? Yes. That is when, the things have reached this ceiling stage. If they say, well, the car is not booked yet, if anybody comes, yes, first come, first serve. If you come quickly, then it's yours. If you don't come, but if they've given you a word that is for you, yes, so what's happening? Hiring over hiring. The hadith doesn't mention about hiring over hiring. It mentions of buying over buying, proposal over proposal. So what we are doing, we are really doing qiyās, isn't it? Because just there in buying over buying and proposal over proposal will create rancor, will create disputation. Here as well, it will create the same thing. Yes, hiring over the hiring of another person is an incident concerning which no textual evidence has appeared. The latter incident to hire will be compared by qiyās to the former incident because both of them share the same illah. Hence, the second incident, hiring over hiring of the previous person, will not be allowed to. Yes. So what hiring? The hukam has been extended of buying and proposal to hiring through qiyās. Yes, it's been extended to hiring. Number 4, there is a clear textual evidence in the Quran prohibiting trading at the time of a call to prayer. Allah subhanahu wa ta'ala says in the Quran, when the call to prayer, azan, happens on Friday, cease to trade. What Allah says in the Quran? وَذَرُوا الْبَيْءِ, give up trading. When the adhan is being given for Friday, obviously in Muslim countries, loudspeakers are going everywhere. So Allah says, cease trading, stop trading. Why? Because if you don't stop trading, and you say, oh, let me wait for another 2-3 customers. Yes, 2-3 customers. Oh, there is another 5 minutes. I will get there by khutbah. What will happen? Shaitan will, take you to the next level, and you will forget, and all of a sudden namaz, salah has started. Jama'ah salah. Now you close the shop and you go there, namaz is gone. So Allah says that soon as the call to prayer happens, give up trading. Give up what? Trading. Why did Allah say? What is the illah behind it? So that you don't miss Jummah prayer and Jummah khutbah. Yes? There is a clear evidence in the Quran prohibiting trading at the time of call to prayer, meaning adhan on Friday. The reason behind is jeopardizing the hastening to prayers at that time and the possibility of missing Friday prayers. All other transactions like marriage by qiyās will be inclusive in this hukam. Now what happens is that, say for example, right? Imam Zubair, or we have got a few Imams, Abdul Rauf, Maulana Hanif, and all this stuff, right? So Sheikh Abdul Rauf is going to do today khutbah and everything in the mosque, at the central mosque, right? Are we understanding? Yes? Now, adhan has been given for prayers. All of a sudden, right? You phone Imam Imam Hanif, right? You say, Imam Sahib, could you do my nikah now? Right? He says, well, azan has already happened, in central mosque. We'll do it after salah. No, I want it now. Yes? He says, well, yes. So, nikah is not in. You say, no, brother, Allah has said that you shouldn't buy, sell. Imam Hanif is trying to, reason with you. Allah says you shouldn't be what? Buying and selling when the azan has been done. You say, no, that is about buying and selling. I'm asking about nikah. Yes? Now Imam Hanif has to, Maulana Hanif has to explain that why, yes, I should not conduct the marriage at this time after azan has been done. He should say that buying and selling Allah has prohibited is because of you missing the prayers. Now if I do your nikah now, you will miss the prayer and I will also miss the prayer, and everybody will say, oh, Imam Sahib is just entering whilst we are coming out. Yes? Are you understanding? Yeah? Yeah. 29 is done. Yeah. Now, conditions for conducting Qiyās. In reality, if you've understood the pillars, the conditions will be just, yes? It's just as the pillars, if you have understood the pillars, yeah? When some, the pillars and the conditions are nearly the same thing, yes? When some conditions are met in the presence of the 4 pillars of Qiyās, then Qiyās is performed. Some conditions are concerning the asl, while others are pertaining to the remaining pillars. It is a precondition that asl is not a fara of another asl. Yes, that's a good thing. Yes. What happens is that Qiyās happens between 2 things. Are you understanding? It's not like you do Qiyās on this thing and then this thing becomes the principle for doing Qiyās on another thing. Yes? Qiyās is done between 2 things, not between this to this, then from this to this. There's no double extension. Yes? It's not that, if you did Qiyās to a fara becomes asl. Yes? Then, a secondary issue becomes now a main issue to do Qiyās on something else. It's not like this. It is from only one main issue to different secondary issues. That's what it's being said. Now, conditions concerning the hukm of asl. It is conditional that hukm of asl, the hukm of asl, we're talking about injunction of the asl, is a legal and practical injunction which is established through the Quran and Sunnah. In terms of its establishment through ijma, the scholars have differed. Some state that it is not allowed to perform Qiyās in that regard. This is because in ijma it is not important to know the legal backing of the hukm. When that is not clear, then it becomes harder to find out the illah. Hence, the extension of hukm to fara becomes impossible in what? Ijma. On other hand, other scholars argue that Qiyās can be performed in ijma. In other words, extension of the hukm to fara through Qiyās in ijma is possible. Their argument is that there are many ways to find out the illah, and not mentioning the legal backing does not have any impact in the performance of Qiyās. This position is a preferred one. However, performing Qiyās based on the Qiyās is not allowed. Now, there are 3 things that we have to understand. The injunction or the hukm is in the Quran. Can you do Qiyās from there? Yes. The injunctions is in the Sunnah, like buying and selling. Just now we gave an example. Can you do Qiyās from the Sunnah to some other issue?
Yes.
Yeah, to a secondary issue which doesn't have a textual evidence? Yes. Now from ijma, can you do Qiyās or not? The scholars have differed. From ijma, can you do a Qiyās or not? The scholars have, what they've done? They have differed. Some scholars, they say you can't. So you say, why do you say that you can't do Qiyās? They say because, when they did ijma, they have not revealed to us what legal backing they used to do it. There is a legal backing, definitely, but in front of us we do not have anything to prove that. Yes? So they have not mentioned any legal backing, therefore we are blank about it. But those who say that no, you can do ijma on Qiyās, they say there is a legal backing. The fact that they have not mentioned a legal backing does not mean that there is no legal backing. There is a legal backing. What we need to do is use our brains and use all our intellectual power to find out exactly what was the legal reason behind which they did ijma. And from there we can do Qiyās. Yes? Now from Qiyās, can you do Qiyās? No. Yeah? So from Quran you can do Qiyās, from ijma you can do, from Sunnah you can do Qiyās, from ijma you can do Qiyās, but from Qiyās itself you cannot do Qiyās. Moving to number 2, it is a prerequisite that the hukm of asl is rationally understood in the sense that it is based on an illah which is rationally grasped, because one of the pillars of performing Qiyās is knowing and understanding the illah which is then extendable to the fara. When it is impossible to rationally understand the illah, then it is impossible to perform qiyas altogether. For this reason, the scholar stated that there is no qiyas on al-umur al-ta'budiyya, humanly incomprehensible issues. These are those legal issues whose knowledge about their illah is only known to Allah, such as the number of prostration and cycles in prayer, and the number of circumambulation around the Kaaba, and the number of going back and forth between the mounts of Safa and Marwa, including some stipulated capital punishment with a specified number of penalty, and so on. However, if the hukum of asl is rationally understood, then it will be allowed to perform qiyas. Did we get it? Remember one thing, not all injunctions are rationally understood. Do we understand that? Yes? Mostly, those injunctions that are to do with worship, they cannot be rationally understood. You can't say, okay, why do we do 2 prostration? We don't know. Why? Maybe somebody might give a wisdom behind it, but there is no any rationality. There's no any legal reason where we can extract. It's impossible, because it's a devotional act. It's humanly incomprehensible thing. Why do we do 7 times tawaf? We can't understand that. So from there we cannot extend the hukum to any other thing. Yes? But if it is a rationally understood thing, like for example, why did Allah make wine drinking haram? Is because of this. Yes. In other things, in other commands, those other commands are comprehensible. Yes? They can be rationally understood. Therefore, you are able to extract the illah. Therefore, it is important to understand the illah. And for that, if you do not understand the illah, this means that it is not rationally understood. It's an incomprehensible, humanly incomprehensible issue. Therefore, we cannot do qiyas. Right? So, the condition is that it is rationally understood matter where illah can be extracted. Yeah? Is that understood? Yeah.
Yep.
Number 3, it is important for the illah, that is, we've used different words to explain illah. There is legal reason, analogical reason, the occasioning factor for a rule. All these are different words to explain that. It is important for the illah to be completely found in farah. Yes. Now, what you have to remember is that illah has to be also be found fully in the farah, right? If the illah is restricted to the asl, then extension of the injunction to the farah will not occur. That is because it is a prerequisite for the asl and farah to share the same illah. For example, the legal reason behind doing qasr in prayers of journeys and not fasting is the journey itself. The objective is to alleviate the hardship. Hence, all hard tasks will not be qiyasable on it, as they do not contain the illah, which is journey. Right. What it is, I will explain to you what it is right here. The illah in any hukm, the illah has to be fully found. No, you have the illah in farah, not in the secondary issue, should be fully found. Yes? There are 2 things. One is hardship, right? Why do we pray qasr when we are in journey? Is it just the hardship, or together with that it is the journey itself? It's journey itself, isn't it? Because at home you could be in the state of hardship, you will not do qasr. Allah has not commanded you to do qasr. Yes? Similarly, fasting, right? Why do we fast why we are allowed not to fast in journey is the journey itself. Yes, obviously, maybe there is a wise purpose behind it, which is the hardship, right? Now, when you look at these 2 items, doing qasr and also fasting, the legal reason behind it is just journey. Yes? The hardship is not, it's not the illah. Correct? Hence, any hard task, you will not say, oh, because today I am totally tired, I will do qasr at home. You can't do that. Do you understand me? Because the illah is not fully found in that secondary issue. Yes? Just for you having hardship, that's not enough. You should be in journey as well. Huh? Is that understood?
Yeah.
It is important that the hukm of asl is not restricted to the asl only, because if it is restricted to asl only, then in that case it will not allow itself to extend to the fara. When the extension is impossible, then definitely qiyas is impossible. For example, Prophet's specific merits and privileges in marrying more than 4 wives and prohibition of his wives of marrying anyone else after his death, these injunctions are specific to the Prophet ﷺ and cannot be extended to through qiyas to anyone else after him. So what happens is that if the hukm of asl is restricted to the asl itself, qiyas cannot be done. If it is just specific to that, it cannot be extended, it will not be extended. Like for example, things that are specific to the Prophet ﷺ, they are specific, they cannot generalize. They cannot generalize to the public, therefore there is no qiyas to be done. Conditions for fara, the fara, that is the secondary issue, should not have a textual evidence concerning its hukm. Why? Because if it has a textual evidence concerning it, then you don't need to do qiyas at all. Yes?
It's not for I.
It's not fara anymore. It has its own hukm. Why should you be doing qiyas there? Otherwise, there's no point in doing qiyas to it. Hence, the statement of the usuli experts is, there is no ijtihad during the exhibition of nas. What they say? They make a very strong point. They say, if there is a textual evidence, don't do qiyas. Don't do ijtihad. Yes? Number 2, the illah of the asl should be found in fara. We've already spoken about that. Yes? Because the condition for the extension of the hukm to the fara is dependent upon the illah in fara. They, meaning asl and fara, must share the same illah, otherwise a complete qiyas will not occur. In cases where there are discrepancies between asl and fara in terms of illah, wherein incomplete qiyas that occurs, that deduction is known as a qiyas mal farik, qiyas analogy with a difference. Right? Are we understanding? Meaning that, the illah should be shared between them fully, completely. If it is half shared, you can't do qiyas, right? Because it will be qiyas with a difference. For example, the example of this is concerning immovable property with preemptive rights, haqq shufa, in which every partner has a right on the property to purchase. Will the preemptive right be divided between these stakeholders according to their stakes and shares, or will it be divided equally? The Hanafiya answered that it will be divided equally. I'll read it, then explain to you, because where it is, it has an explanation behind it. I'll read, then I'll try to summarize it quickly. While others stated that it will be divided according to their portions, the others argued that the reason every stakeholder will be divided according to his stake is because the division is based on the qiyas on the partnership on earning and produces. Every partner receives according to the percentage of his share in the partnership. Therefore, by qiyas, the stakeholders possessing the preemptive right will be entitled to their share according to the percentage of their share in the preemptive right. The Hanafiya responded that what others have performed is qiyas mal farik, because in partnership in the earnings, and produces are a product of the initial ownership, which is divided between the partners according to the percentage of their partnership in it. Hence, they have to divide their earnings proportional to the percentage of ownership. That is not the case with Haqq Shufa, because what the stakeholders receive, because what the stakeholders received, their shares, is due to their preemptive right, which is not a product of their ownership in the property. They do not own the property, they only have the preemptive right to buy. Hence, a preemptive right cannot be equal to the initial investment and proportional ownership of the partner in trade partnership. Therefore, the Hanafiya concluded that to perform Qiyās of the proportional distribution of the preemptive right on a different issue, that is a business partnership containing proportional investment, is Qiyās Malfa'alik, which is an incomplete. Thus, according to the Hanafiya, every stakeholder in Haqq Shufa will receive a share equally, unlike in the instance of business partnership. Right. What is Haqq Shufa? It is a preemptive right. Right? I'll give you an example. I have a land of 1,000 kilometers square or miles square. Really big land of how much? Let's say 100 square miles. It's a very big land I own, right? Now, it's a big land. Now, this is my land, and I have about 8 neighbors. How many neighbors do I have? 8 neighbors. Neighbor 1, right? He has a very big land, neighbor 1. Yes? Which covers about 30% of the boundary. 30% of the boundary. Or 40% of the boundary. Neighbor 2 covers maybe 20, others little, yes? So, when I come to sell the property, all these have preemptive right. I should not sell it to anyone outside. First, I have to offer them to buy. What I have to do? I have to offer them to buy the land. Now, because I've got 8 different neighbors, right, to this big land, right? It's a farmland, yes? Big farmland. I cannot sell it to outsider. First, I have to sell it to them. This is known as what? Preemptive right, which is known as Haqq Shufa. They have greater right than an outsider. So they will be offered first to buy. Yes? Now, when they are offered to buy, right, what will happen? All of them agree to buy. All of them have what? They've all agreed what? 8 and 8 neighbors, they've agreed to buy. Now, when it comes to buying, right, the neighbor who's got bigger, land, yes, and is adjacent to my land and has got bigger boundary, he will say, well, I should get about 40% share of the land. Yes? Yes? The other will say, well, I should get about, because my land is about 30% bordering, the border is about 30% of your land, right? I should get 30% of your land. Yes? Another one who's got about 20%, he will say that. Yes? Are we understanding, yeah? Let's say it is about 80 square kilometers, the land, right? And there are 8 people. According to the Hanafis, everyone will get what? 10 square kilometers of that land. Understood? According to the Hanafis. But according to others, apart from the Hanafis, they will say no. They will get proportion to the bordering, to the borders. If I've got 30% bordering, 30%. So the Hanafis, they have protested. What the Hanafis have done? They've protested against the others. The majority of scholars, they said, you're wrong in that. They said, why are you saying we are wrong? He said, okay, tell us, the Hanafis told the majority of scholars, tell us how did you come to that conclusion? They said, the reason we have come to that conclusion, we have done Qiyās. What the others are saying to the Hanafis? Yes? The reason why we have come to that conclusion, we have done Qiyās. So they say, on what have you done Qiyās? On what have you done the Qiyās? So the majority of scholars, apart from the Hanafis, they say, we have done Qiyās on investment. Yes? Company, investment. Like if you have, we are all partners, right? If you put 30% in it, what should you get? Return 30%. If you put 40% in the company, you get 40% share. So it should be proportional. So we have done Qiyās on that. The Hanafis, they say that this Qiyās is an incomplete Qiyās. What the Hanafis have said? This Qiyās is what? An incomplete Qiyās. Why? Because all of you are, this is an initial investment that you have done on a company, on a share, on what you call, on different shares from the beginning. Here, you didn't have a share. It's just when this man is come to sell, right? Yes? And he's saying that you guys, you want to buy or not? Because you are the first neighbors, so you have a preemptive right. Do you understand? So from the beginning, they didn't have any share they didn't have any right to that land. Yes? So therefore, everyone will have an equal share. Inshallah. I'll just finish with illa, inshallah. Okay, illa, it is a confirmed fact among the muhakkikun that injunctions have been placed due to the objectives, interests and wisdoms and reasons behind them. All the injunctions of Allah subhanahu wa ta'ala, there are reasons behind it. Yes? So some of the reasons are comprehensible. Yes? So we can extract illa out of it. Yes? Some of the injunctions, we can extract some wisdom out of it, but we can't grasp much. And some we might not even understand, but there are reasons behind it. The fact that we don't understand the reason is because our intellectual ability does not reach that level, right? Does not mean that there is a reason, there's no reason, there is a reason. So, wisdom in a hukm is what the lawmaker intended to enforce to grant an interest, benefit or repel harm from the legally responsible Muslims. Though an injunction may have a wisdom behind it, however, the injunction does not depend on the wisdom from which Qiyās can be performed. However, the injunctions are connected to their legal reasons instead for the performance of Qiyās. Because wisdom is conjectural, unclear, which leads to anarchy, confusions and countless claims, while legal reason, is a clear descriptor. Now, what we have to remember is that we cannot do Qiyās using wisdom. What is being said here, don't use wisdom to do Qiyās, but use a legal reason which is completely crisp and clear. Yes? I'll give you an example. We were talking about fasting when on journey, Allah says, yes? Yes. The wisdom behind it is the fact of hardship. Yes? That's the wisdom. But don't try to use that wisdom to try to do Qiyās to other things. Rather, use the legal reason which is behind, which is the journey itself. Yeah? Because, wisdom sometimes is not that clear. Drinking wine, Allah says that, drinking wine leads to fights and brawls and this and that and many other things and enmities and this and that. Yes? So don't try to use these these wisdom or wise purposes to do Qiyās on other things, but try to use the legal reason itself, illa itself, right? Why? Because sometimes wisdom or wise purposes can be unclear. Yes? Hence they are not, you cannot use them as a basis to do Qiyās from. Yes? Or, is that clear? Yeah. Though an injunction may have a wisdom behind it, however, the injunction does not depend on the wisdom from which Qiyās can be performed. However, the injunctions are connected to their illa, legal reasons stated for the performance of Qiyās. Very simple. There's two things. An injunction has a legal reason, has many wisdoms behind it as well. Don't try to use wisdoms to do Qiyās, but use the legal reason to do Qiyās. Why? Because you know these wisdoms sometimes could be ambiguous, could be debatable. Is that clear? Because wisdom is conjectural and clear, which leads to anarchy, confusions, and countless claims. People will claim many things, while illa, legal reason, is a clear descriptor. Thus, the usul experts have mentioned the injunctions are related to their ilal, to their illa, and not to their hikmah, wise purposes. Yeah, hikam, right? In summary, this is because hikam, that is wise purposes, can be ambiguous, unclear how to establish. Hence, it will be rarely used to bifurcate secondary issues based on that. Maybe sometimes it might be used, wisdom might be used, but not always, right? Right? So the default position is that you don't use wisdoms to do Qiyās, but you use what? Illa, that is the legal reason, to do Qiyās. Don't use hikmah, wisdom, to do Qiyās, but use illa to do Qiyās. Yes? From this explanation, the difference between illa and hikmah is clear. The statement of usul experts is the injunctions are related to their ilal, which is plural of illa, and not their hikam, plural of hikmah, wisdom, also points towards the fact that hukam will be found whenever there exists a illa, even when hikmah postpones itself from appearing on some occasions, and will cease to exist whenever illa is absent, even if the hikmah is present on some occasion. That is because the correlation between the illa and hukam mostly signifies the presence of hukam, mostly signifies the presence of hikmah. If it delays, that is a rare case which does not impact the predominant occasions, because the consideration is for the predominant case against the rare cases. Then it is important for the illa to be an apparent descriptor and able to extend. Many times what happens, right, for example, you could drink to an extent that you are what? Intoxicated, but you're not causing brawls in the pub, right? Or you're becoming too friendly. So hikmah, you cannot use hikmah to do Qiyās on, right? Yes? Is that understood?
Yeah.
Say for example, you end up taking some tablet, right, that make you violent, right? Obviously, we might say that you shouldn't use it because it's causing violence, but we'll not say that we are doing Qiyās from alcohol, because that also causes that problem. You cannot use that, the wisdom, right? Because sometimes it could happen that you end up drinking, right? And you rather than you causing enmity with others, you might become more friendly with others. That's possible as well. Yes? So hikmah itself is not that crisp and clear for you to, yes? Or maybe that hikmah might delay itself. Maybe first you will be friendly and jolly, then you will start brawling. Yes? Yes? So hikmah might postpone. But illa in itself is there, right? From beginning. So that is more crisp and clear to use as a for Qiyās, not the hikmah. Jazakumullah khair. Assalamu alaikum wa rahmatullahi wa barakatuh. What time is it now?
30.